Hello guys, my name is Derek Moma. This is paper 3, Introduction to Law and Governance. So tonight we're going to look at the objectives. So we have objectives for studying Introduction to Law and Governance. So our objective is to equip you, the learner, with knowledge and attitudes that are going to enable you to apply the principles of law and legal systems in an entity and ensure compliance with the basic principles of governance. So whichever entity you're going to work for, you will need some knowledge on introduction to law and governance so that you are able to make the right decisions and you're more competent with this knowledge. Now, the outcomes that we expect for someone who is going to pass this unit should be able to demonstrate knowledge of essential elements of a legal system, to demonstrate knowledge of legal personality, to be able to apply the law of tort and contract in various scenarios, to be able to apply general principles of business law in practice, and to apply fundamental principles of ethics in practice. Now, today we're going to look at legislation as a source of law. So we are under sources of law, and we having looked at the Constitution as a source of law, now we're going to legislation as a source of law and written law. Now, legislation is also known as enacted law. So legislation is a law that has been discussed and has been passed by a body that is mandated by the law to form that law, to enact that law. So the law goes through various stages for it to be said to have been enacted. Now, these are those, legislation are those laws that are passed by Parliament. In Kenya, it is understood that it is Parliament that passes laws. Now, the power to legislate is a power that is derived from the Constitution. And we're going to see that Article 94(5) provides that there is no other body other than Parliament that has power to make a provision having force in law, except if that other body has been given authority by the Constitution or some other piece of legislation. Now, laws are made by Parliament. They're made either directly or indirectly. Now, the sources of law, direct legislation is legislation that Parliament passes actively on its own. So it will be introduced by a bill, discussed, takes the 5 stages, and goes to the President for assent. And therefore, it becomes a direct legislation. Parliament has to pass it directly on its own. So they normally undergo the ordinary process by which Parliament passes laws. And in this case, Parliament uses its own power to pass laws, the power that they derive from Article 94(5) of the Constitution to pass laws. And in this case, they need to be assented to by the President. Now, there are instances where the Constitution expressly tells Parliament that they need to pass legislation to operationalize some of the provisions of the Constitution. So in this case, the Constitution directly tells Parliament to make a law. It is a direct power conferred by the Constitution on Parliament to pass these laws. Now, some examples are Article 15(3) says that Parliament shall enact legislation establishing conditions on which Kenyan citizenship may be granted to individuals who are already citizens of other countries. So in this case, the Constitution specifically places a responsibility on Parliament to create a law that provides for people who are already citizens in other countries to see how they're going to become citizens of Kenya. Article 173, the issue of the Judiciary Fund, where the Constitution says that Parliament shall enact legislation to provide for regulation of the Judiciary Fund. So this is another direct manner in which the Constitution tells Parliament to make a law. So these are some of the ways in which Parliament derives its power to make laws. Article 47(3, the Parliament shall enact legislation to give effect to the rights in clause 1. So these are rights that are prescribed in the Fair Administrative Action Act. So in these instances, you'll note that the Constitution is specifically directing Parliament to enact legislation. So these are some of the powers. So we begin with Article 94.5, Article 15.3, Article 173, Article 47.3, just to name examples. There are so many other instances where the Constitution tells Parliament to make laws. So we're going to look at indirect legislation as well, as aside from direct legislation. And indirect legislation, these are laws that are provided out of a power given in statute. And sometimes these powers are in the Constitution. So they give you a power to make laws, yet you are not Parliament. So some of these are in the Constitution itself. Some of these are in various acts of Parliament. And we're going to see some examples. So one example is that the Civil Procedure Act confers authority upon the Rules Committee to make rules that govern procedure in court. So the civil procedure rules govern proceedings of a civil nature in both the High Court and in all the subordinate courts. And now, having noted that, the Constitution says that the Civil Procedure Act says that the Chief Justice shall form a committee, and this committee, its roles would be to come up with rules that govern procedure for operation in courts. So this gave rise to the Civil Procedure Rules and the amendments to the same. So that is an indirect manner in which legislation is carried out. So let's look at enactment of laws by Parliament and some of these processes by which Parliament comes up with a law. So it starts with a bill. So a bill is normally like a draft act of Parliament. It's like a sample act of Parliament. And now this draft, the moment it is approved and assented to by the President, it is going to become law either within 14 days or within the period in which is indicated in the bill. So a bill is drafted by an expert in the area of drafting legislation. So there are people who are trained in drafting of bills, and that is their role. So they draft these bills and present them to the mover of the motion in Parliament, the person in charge of the bill. So they do the work of drafting, and then they present it to the person in charge of the bill for introduction to the House for discussion. So let us look at the process by which the various categories that bills fall into. Now, they're public bills. So examples of these are normally bills that affect the public at large. So like when health laws are being amended, it is Health Laws Amendment Bill. So it is a bill that affects everyone. So an example we have is like the coffee bill is a bill that affects the public at large. So it is a public bill. And then there are private bills. These ones may not affect the public at large. They go to a specific sector. So an example, you can say alcoholic drinks control bill. So if such a bill might be brought to the floor of the House, may be presented from the cabinet through the specific minister or cabinet secretary concerned in which the ministry falls. Another one is a private member's bill. So a private member's bill, this is a bill that is brought to the House by a specific member on an issue that either is a problem that faces his people in the area that he represents, or it is an issue that has been raised to him by other members of the House. Now, let us look at the stages that a bill goes through before it becomes a law. So the bill is supposed to be introduced in the National Assembly, and it undergoes 5 stages before it goes to the President for assent. So the first stage is the first reading. And the first reading is a formality, is a mere formality. So the idea is that you are presenting the bill to Parliament, and you need to let members know that there is a bill that is being brought to Parliament. Be aware, they just need to be aware. Nothing is being done at this stage. It's a mere formality, and it's to introduce the bill to the members of Parliament and tell them there is a bill that is upcoming, and you need to be aware of it. So if the bill is approved at this stage, copies are going to be shared with the members so that they're able to read through it and be able to debate on it. So at this point, the leader of majority or the person who is responsible for the bill may set an appropriate time for the second reading and inform the House. So still on stages of passing a bill, then it now goes to the second reading. So at this stage, the person in charge of the bill or the House of Majority, of the leader of majority, is going to explain the purpose of the bill and the major issues that arise out of the bill. So that is the second reading. Now, from the second reading, this bill is going into a stage known as the committee stage. So at this second reading, each member is allowed to speak, but they speak only once, and they vote for the same by a majority of members of Parliament. So if a bill is voted for by a majority of members of Parliament in its favor, it is now going to pass to the report stage. Now, I had said it is going to the report stage. Rather, it is to the committee stage. So at the committee stage, this is where the House forms a committee to discuss the bill. So the House at that point is no longer the formal Parliament that we know. So at this point, this is the stage of reading and scrutiny. So the committee might decide to handle the business by the whole House, or decide to handle the business by a smaller committee. So the committee, either of the whole House or a smaller committee, will now report its findings to the whole House of Parliament. Upon reporting its findings, at this point, the Speaker is supposed to act as a chair. So at this point, the Speaker doesn't exercise his powers as a Speaker. If it's a committee of the whole House, then the Speaker will be the chair of those proceedings or of that committee. And the committee is going to make its findings and report them to the House at large. So by reporting this is at the stage known as the report stage, which is now supposed to be our fourth stage. So at this point, members have had a serious scrutiny of the bill. Members have had a serious discussion of the bill. The committee, through its chairperson, is going to report to the committee, to the House, to the whole House rather. So at this point, members have a better informed discussion about the bill at the report stage. And what they may do is that they may adapt it either with amendments or without amendments. And at this point, they may pass the bill. Now, at the third reading, if a bill has been passed at the report stage, so once it goes to the third reading, at this point, they don't discuss the details of the bill. They don't make major amendments. So the only thing they're going to do is that they're going to make minor drafting changes to the bill. Minor drafting changes, a few typos, a few typing errors. So those are the things that are looked at. a few mistakes here and there. Those are the things they look at. Now, the Speaker of the House is going to forward the bill to the President now for assent. Now, does the President have to sign it? So at this point, most of the time, this bill is most likely going to become an act of parliament. So the role of the President is a role of mere ceremonial importance. So the President does not make major or fundamental changes to the bill. So as per Article 115 of the Constitution, is that the President has 14 days to either sign the bill into law. This process of signing is what is called presidential assent. So he has 14 days to either assent to the bill as it is, or he doesn't have to sign it as it is. He can refer it back to the House for amendments with some recommendations on the issues that he has reservations on. So he can give his suggestions, make a few changes here, make a few changes there. Then I'm going to sign with those changes. And the House does not have to follow what the President says, does not have to follow the President's recommendations. So if the President assents to the bill, it shall be published in the Kenya Gazette so that people are aware of it. So it shall be published in the Kenya Gazette within 7 days. And therefore, it's either going to become a law within 14 days of publication in the Kenya Gazette, or it is going to become a law if on the date when the Act stipulates a date. So if the Act has a specific date when it is going to become a law, then it will become a law on that date. If it doesn't have that date, it is going to become a law within 14 days. Now, the President may reject the bill. So upon rejecting, what happens? So if the President rejects the bill, what is going to happen is that the bill will be referred back to the House with his comments and his reservations. And the House may pass it again without any comments or without any changes or having accommodated the President's recommendations. So for example, if the President decides that a few clauses need to be removed, the House may decide to remove those clauses and pass it again, send it to the President for assent, at which point he is likely to sign. Alternatively, the House may pass it with a few accommodations of what the President said, and the President may sign it or may not sign it. However, if the House passes it again in whatever form it is, now at this point, the President either has 7 days within which to assent to the bill or refer it back to the House once again with his comments and reservations. So if the President having sent this bill back to Parliament with his comments and reservations for a second time, the House may pass it or reject the recommendations and pass it as it is. So they may either accommodate the views of the President or avoid accommodating the President. So at this point, if they send it back to the President has either 7 days to assent to the bill or refer it back to the House. If it doesn't send it back to the House nor assent to it, so what is going to happen is that it becomes a law within 7 days. Now, we have a question. That is question 1B of the 2015 pilot paper. Explain the procedure to be followed once the President declines to assent a bill passed by Parliament. So when you're told to explain the procedure, you need to express an understanding of the law. So you need to say, you need to start with the point when the law has been passed. So upon being passed as a law, as a part of the third reading, the Speaker of the House is required to refer the bill to the President for presidential assent. Having sent the bill to the President for presidential assent, the President has a choice to either sign the bill into law or decline and refer the bill back to Parliament with his comments, recommendations, or reservations. In the event that the President sends the bill back to the House with his comments or his reservations, the House is supposed to either pass the bill once again as it is, or accommodate the recommendations made by the President either fully or partly. Where the House has passed the bill once again and sent it back to the President has 7 days within which to either sign the bill once again into law or send it back to the House with further recommendations and further comments. In the event that the President does neither assent to the bill nor refers it back to the House with his recommendations, the bill will become a law within the next 7 days. So that is, I think we have tackled that question. And now we need to move on to another aspect of legislation. And in this case, what we're discussing is that these laws need to comply with the Constitution. So where a law doesn't comply with the Constitution, it is going to be declared a nullity. It is going to be declared as void. So Article 2.4 comes in of the Constitution that says that a law that is inconsistent with the Constitution is a nullity from the outset. So the right court to hear matters of such a question is the High Court. According to the Constitution, it is the High Court that is going to hear matters of whether a law is constitutional or whether it complies with the Constitution. So in Nairobi, the High Court is divided into divisions, and the correct court to file such a petition would be the Constitutional and Human Rights Division of the court. Now, moving on swiftly, we need to look also at another aspect of legislation known as delegated legislation. So delegated legislation is also known as indirect legislation. So Parliament does not always have enough time or even the expertise to legislate on each and every other issues that arise in our society. Parliament does not have the time to deal with each and everything that arises outside here. So it is for this reason that it is necessary to give other bodies the power to legislate. So once power to legislate is given to a body, that body cannot also delegate that power to another body. So the body that is required to give delegated legislation or to make delegated legislation cannot also decide to delegate that duty to another body. If that other body so decides that it is going to delegate to another body, the maxim that is applicable is known as delegatus non potest delegare. So that means that is simple Latin. That means that the delegate is not allowed to delegate further. So these pieces of legislation normally takes the forms of rules, orders, and bylaws. So an example is our civil procedure rules, which come into being on the basis of the Civil Procedure Act. Now, still on delegated legislation, so the Civil Procedure Act empowers the Chief Justice to form a rules committee, which is going to come up with rules of procedure in court. Now, these rules are known as the civil procedure rules. Still on delegated legislation, so statutory instruments, rules, and orders can be made by CSS in charge of various departments. And so they need to be submitted to Parliament for approval before they gain the full force of the law. So a law that is made on the strength or on the basis of delegated legislation can be declared invalid or void. And this is where either you are supposed to legislate on matters of say wild animals, then you decide to legislate even on stray dogs. So you are basically going beyond the power. So if you're told to legislate on wild animals, you need to legislate on wild animals. You need to read the text clearly and legislate on the area, on the specific area that you've been given power to do so. So you need to legislate within your power to legislate. So a law that goes beyond the power to legislate. So you're given a power to legislate and you go beyond that power. That law is going to be declared as ultra vires. That it is beyond the power that was given to the delegate. Now, why do we need delegated legislation? Now, we need delegated legislation because one, Parliament doesn't have enough time, obviously, to do all this, to make all these laws, to pass all these laws. Some of these laws, the other is urgency, that the way Parliament runs its business, it is not going to have to pass a law requiring instant intervention at the required time. Say a pandemic has hit the country and laws need to be formulated in order to help citizens not get infected. There is no time to rush to Parliament to pass these laws because the manner in which Parliament moves is not at the same speed at which other laws can be passed. So where there is an urgency, then Parliament, instead of Parliament taking substantial time to make the law, then you need the delegated legislation so that another body that has a faster mechanism of making laws is able to pass the laws in that specific sector. Also, it's the Parliament, as I have said, so Parliament will not be able to make laws that are instantly required. So that is under urgency. So you remember how the rule to wear masks and other COVID regulations became law? So they originated from the CS. So they did not even start in Parliament. Now, technicality of subject matter. So the question I'm going to ask you is whether your MP is comfortable to discuss matters of technical nature. So is your area MP comfortable to discuss matters of technical nature? Maybe your area MP is not someone who is qualified in any of the technical units, of the technical areas. So will your MP be able to discuss matters, say, information technology, matters of medicine, finance? So when they can't contribute meaningfully to such areas, then it is better for people in that sector to come up with the rules regarding that sector, to come up with laws that are specific to that sector. And now those laws are given parliamentary approval before they become laws. So sometimes when a matter is of a technical nature, then it poses a problem to Parliament to legislate on it. Now, flexibility. Parliament has what I can call a rigid manner in which they need to pass laws. So it needs to go from the whole time of tabling the bill through the first reading all the way to presidential assent. However, if another body has a more flexible method of passing laws, then probably it is the better body to pass the law and present it for approval. Now, question 1B of the November 2015 says justify the need for delegated legislation. So I think we have answered this. These are the answers to that. So the first is lack of time on the part of Parliament. The second is that where law requires urgency, Parliament might not be able to pass that law as instantly as it is required. There's also the technicality of the subject matter. So where the subject matter is of a technical nature, then probably the persons sitting in Parliament are not the best people to discuss such matters. And also the aspect of flexibility, that this other body might be flexible enough to pass laws in a timely manner, in a better manner, as opposed to the National Assembly or the Senate. So I think that one is well answered. Now, having created these rules, we're going to present them to the court. Now, the court is the one that is mandated by the Constitution to come up with interpretations of that law. So how will the court interpret legislation? So this goes to the rules of statutory interpretation. Now, the rules of statutory interpretations are three. The main rules are three. One is the literal rule, and the other is the golden rule. The third is the mischief rule. Now, to start with the literal rule, this is where the wording, this is a rule that a judge or a magistrate will adapt, where the wording of a section are so clear. So you need just to follow the law as it is. So if the law says that you need to park a few millimeters from the curb, then that is where you park. So the court will just analyze look at the evidence and see how far you had parked, make a decision. So they don't need anything else. So in this case, the law is in black and white, and the court is able to create a distinction between the conduct that was given and the conduct that is proven before them and the law that is there. So in this case, it will be so easy. You just follow the wording as it is. This is where this applies where there is no ambiguity in the law at all. Now, the golden rule, this is where the judge finds out, or magistrate finds out, that if they follow the rule as it is going to lead to very absurd conclusions. So in this case, the judge is going to look at the law and decide it or interpret it in a manner that gives meaning to the words that are given in the statute. So having given meaning to the words in the statute is when now the judge comes up with a better reasoning that suits the case at hand. So the mischief rule is the third. So this is where the judge focuses on the mischief that the law came in to correct. So in this case, the judge is going to focus on, she's going to look at the rule, look at the conduct that happened, and then look at what that law came in to remedy and give an interpretation that is going to help that rule curb the kind of mischief that has been complained about. Now, this answers question 1A of the November paper for 2016, which says explain 3 rules that courts apply in interpretation of statutes. So I have told you, the first is the literal rule, where if the wordings are very clear, the judge will apply it literally, will apply it just as it is. So if you are going to forget the definition, just remember, literal rule is for literal interpretation. So just as it is, just carry it and paste it in the judgment. Golden rule is the other, and it refers to where the use of the words might lead to an absurd conclusion. So the judge will avoid the literal rule in this case and decide to give these wordings in the statute some form of meaning as he understands them or as it might have been intended, so as to modify them and make meaning and give an appropriate judgment. Now, the mischief rule, this is a rule of interpretation where the judge focuses on the wrong that was committed or the wrong that Parliament passed a law in order to deal with it. So in this case, the judge is going to focus on giving parties a remedy that is going to help them in line with the mischief that the law came in to deal with. So I think that is answered. That is the end of our class today. Thank you for listening in, and my name is Derek Mwoma. See you in the next class. Thank you very much.